Good morning. I'm Kimberly Craig, the President and CEO of the Monterey County Business Council. Thank you for joining us today. We are pleased to partner with the Small Business Development Center, also known as the SBDC, to offer these time-sensitive topics to you via webinar. The Monterey County Business Council is a membership-based organization that works together with private business, the public sector, and nonprofit organizations. We are always looking to expand our network, so if you think we're doing good work, we'd love to have you as a member. You can find a membership application on our website, mcbc.biz. Additionally, our partners at the SBDC provide no-cost one-on-one consulting for businesses. They offer workshops and webinars to businesses in Monterey and San Benito counties who register for their services at calcoastalsbdc.com. MCBC and SBDC have been offering free webinars on small business solutions during the pandemic, and we'll let you know of upcoming discussions on opportunities and timely updates that affect you. I do want to thank our partners, the SBDC, the City of Salinas, the County of Monterey, the U.S. Small Business Administration, and the California Governor's Office of Business and Economic Development, as well as TPO Human Resources today. Additionally, I want to give a shout out to Luis Alvarez of Alvarez Technology Group. The team over there is producing our webinar today. I do want to encourage you to ask as many questions as you want. To do that, please use the raise hand feature of Zoom, and we will answer your questions at the end during Q&A. We also are recording this webinar, and we'll send you a link with the recording so you can review today's class. We will also send out the contact information for our speaker today. With that, I'd like to go over the agenda. We have Cindy Merzon, the director of Cal Coastal Small Business Development Center, on the call today. She will be assisting with questions and answers on anything that you may have regarding small business development and some of the grants that we have out for both state and federal opportunities for our small businesses. With that, I do want to introduce Michelle Stanford with TPO Human Resources. Michelle is the lead consultant and training specialist over there. And a little background on TPO. Since 1991, TPO is a human resource management firm located in Monterey, California. Their team of highly experienced, certified HR professionals partner with clients to provide expert support and advice needed to comply with complex employment regulations. As employers, we must be diligent about watchguarding employees' well-being, which operating within scores of employment regulations and policies. Isn't that the truth? Most recent is today's topic, and we look to TPO as a trusted expert to provide this important briefing. With that, Michelle has 30 plus years of senior level experience in human resource operations, as well as organizational and leadership development. With that, I'd like to welcome Michelle. Thank you.
Kimberly, thank you so very much. I'm pleased and happy and excited to be joining you today, and thank you for sponsoring this event. And folks, I just want to share that over this past year, as we've been going through the COVID pandemic, we have had numerous opportunities to partner in various COVID related events. And today I'm happy to talk to you about the most recent changes in California employment law, and that has to do with the California CFRA expansion information briefing. So forgive me, I have a little trouble multitasking here, so I'm trying to talk and bring up my presentation at the same time. So I think I finally did it. Maybe I got a B+ on this one, but here we go. So thank you again, Kimberly, and your entire organization. It's always a pleasure to work with you and partner with you and the entire team as well. And also a shout out, as you did, to Louis for being the master behind the scenes to make sure all of this comes off swimmingly. So let's go ahead and get started here. So always when we begin these types of live virtual events, it's important for me to share with you that what I have to share today, it's for your information. It's to help you get increase your knowledge, get a sense of hopefully a little bit of comfort and confidence in terms of what you didn't know before about this topic, that you'll have a better understanding of it after we get through the next 55 minutes or so. This is not intended to be legal advice, And certainly for matters that are of significance and importance to you and your organization regarding HR matters, you want to be sure that you contact your legal expert, your HR lawyer, and or related. So just wanted to do that quick disclaimer for you folks. All right, so as with all of our programs, I love to first ask and check in with you folks. And so before we get started here, I just want to hear, so tell us how you're doing. Are you treading water? Are you hanging in there? Are you doing well? Or it just really depends upon the day we ask you. And so we're gonna have you respond to this, and then we'll, in just a couple of seconds, see what you have to say. Oh, isn't this lovely? Early on in the pandemic, when we would do the various COVID live virtual events, we would ask the same kind of thing. And at that time, a year ago, we found that the responses were more around the I'm just treading water, trying to survive this whole thing. And then we had pretty much the same population of those that were treading water. However, we didn't have as positive as responses we're having here this morning. So this is really, really good to see. And I'm with you. It kind of depends upon the day in which you ask me. And so hopefully today is one of those better days for you. So let's dive in, and let's get my mouse to cooperate with me. So what we're going to talk about, or what I want to share with you today, is a new California law that went into effect January 1st of this year. And for those of you who have 5 to 49 employees, you're a 5 to 49 employer, this is going to be a brand new law for you. And for those who have 50 or more employees, it's also an important change for you because they made changes in terms of the definitions, the eligibility, and how the CFRA benefit should be administered. Now, as I go through this information, I'm not going to go into a deep dive because first, we don't have enough time. We could spend a whole day on this topic and still not have enough time. But we're going to give you a couple of examples that illustrates how all of this new leave works. And then at the end, I'm going to share with you, okay, now I've got all this information. Oh my gosh, now what do I do? What's my next step? And please don't worry. It's fine. We're here to help. And we've got some very simple and easy next steps for you to do in terms of how you set up, prepare, and administer this important change in the California law. So let's do a couple more polls here. I'm getting a little greedy on polls. The first one I want to ask you is, how many employees do you have in your organization? Do you have under 5? Do you have to have between 5 to 29, 20 to 49, or do you are 50 plus or more employer? And then the next poll I want you to respond to is, have you managed CFRA leaves in the past? Are you new to the topic? Are you feeling pretty comfortable with the topic? And as you're responding to this, I will look forward to your answers. So we'll see those come up here in just a second. I'm going to take a sip of water while you're responding. Okay, so 20% of you have between 1 and 4 employees. And the reason why I asked this question of you is just for this purpose, to see how many of what buckets you are. If you have less than 5 employees, today's leave does not apply for you. So deep breath, sigh of relief. You don't have to be concerned about CFRA. Now, if you are on the borderline, so if you have 4, but before COVID hit, you had 5, you had 6 or 7. And if you believe that now that we're slowly reopening our businesses, you're going to get back to 5 or 6 or 7 employees, which includes part-time employees, then you want to stay on the line. But if you believe that, hey, I'm not going to get to that number 5 threshold, I'm a very small organization, I'm a small restaurant, I'm a small retail operation, whatever that might be, then you don't need to stay on. If you'd like to, you're welcome to. For those of you who have 5 to 29 employees or 20 to 49 employees, there's a slide, some nuances and some differences that you want to pay attention to. And I see here we have no employers that have 20 to 49. So actually that's good news. That's a little bit less than I'll cover or pay attention, emphasize today. And we do have a few folks, 40% of you are 50 plus. So this is very helpful to me to kind of help navigate through the slides for this morning. And then I'm also very interested to see 20% of you are new to this topic. Please don't worry. This is not something that you must feel like, oh, I have to know everything today after this 60-minute virtual live event. No, you don't. This is a process, and it's a step-by-step process. And you take it one step at a time when you are in a situation that you need to address this with your employees. And half of you say, yeah, but I still get confused. Boy, I tell you, we get it. There will be instances when we have members or clients that call us and they'll throw us the scenarios like, whoa, that's a new one. And so even with us as experts, that we do this as part of our job, we do this as the day in the life of everything that we do. Sometimes we have scenarios that we have to step back, pause, and think, well, wait a minute now. How does this coordinate or does this stack? And so please don't be concerned. Please don't get too worried. Just know you have a resource to come to. And the other 30% of you are saying, yep, I can do this pretty well. And 10% of you say, yeah, I'm pretty confident. And just know that even if you get thrown for a loop at some point, you know where to come and get assistance and help. So let's keep going. So let's first jump in with a basic overview. And for the 50 plus employers, this is going to look familiar to you. And the way I typically respond or I participate in these kinds of events, when there's information that I'm already familiar with, I'll typically kind of just go through a checklist to say, yep, I'm good on this. Oops, this one I wasn't so much aware of. This one I'm good. And so that may be a good way for you to kind of go through this as a refresh. So what CFRA does is it provides up to 12 weeks of job protected, unpaid CFRA leave within a 12-month period. And it also includes continued paid health insurance premiums. So what that means is that as an employer, if you provide employee health benefits, and there's a portion of health premiums that you pay for, you need to continue those through that 12-week period. Now, when does this happen? If your employee needs to go out for their own serious health condition, if your employee has a member of their family who has a serious health condition that they need to take care of, or if they need time to bond with a child, or if it is for exigencies created by a military service. So let's explore this a little bit deeper. Specifically now, it's 5 plus employees. It used to be 50 plus employees. So this includes employees with 12 months of service. And oh, by the way, that doesn't need to be continuous service. So for example, let's say I worked for you 7 months 2 years ago, and I recently rehired with you 3 months ago. And so now I come to you and I say, hey, I need to take a leave of absence for my own serious medical condition. Well, I'm not eligible because with the 7 months I worked for you previously, and now the 3 months I've just completed of service with you in a rehire, I have a total of 12 months service. So I'm not yet eligible to take CFRA leave. So that's one of the categories. The second bucket here is not in addition to the 12-month service. I must also have worked 1,250 hours worked in the past 12 months. Now, so oftentimes I will get questions that come in from members or clients and they'll say, well, does this include part-time employees? Yes, it does. If they have worked 1,250 hours in the past 12 months, they are covered under this benefit as well. which I want to pause here because one of the things that I neglected to state is that for these events that you've attended through the Monterey County Business Council in the past, you're probably familiar with the feature on the Zoom program. There is a question feature in which you are able to ask questions. Please use that feature, type your questions as we go through this, because I want to make sure I cover those questions with you as part of this program. And if I happen to be kind of bulldozing through the information and I'm not paying attention as I should, my friend Lewis is going to call out and say, hey, Michelle, I see a question's come through, and I'll pause and make sure I answer that for you. So good. Now let's keep going. So let's take another slice and dice of CFRA. And I like to do this because you kind of dissect it in terms of different ways of looking at it, which it helps increases understanding. So again, it's for a serious health condition for your employee. It excludes pregnancy. Now, I'm going to test this out to make sure you folks are comfortable with the question screen. And in the question field, I would like you to type, why do you think it excludes pregnancy? Why does CFRA not include pregnancy? And as you're typing your answers, I'm going to keep going. And if none of you are brave enough to type an answer, don't worry about it. It's no problem. I'll tell you the answer to that in a minute. Okay, so then for the family member, it includes a child, a parent, a spouse, registered domestic partner, grandparent, grandchild, an adult child, as well as a sibling. Now, for the 50 plus employers, take note because there's some nuances and changes in who's eligible. So before, prior to January 1st, it did not include the grandparent, did not include the grandchild, it did not include the adult child 18 plus, nor did it include the sibling. Those are new eligible family members for the enhanced CFRA. Now, for bonding, it includes a newborn, it includes an adoption, it also includes foster care, can be any one of those three. And for military exigency, it includes both covered active duty or for employees who are called to active duty. Okay, Lewis, I'm not seeing anything. Did you see any responses to the question that I asked?
I have not seen any, no.
Okay, so folks, the reason why CFRA does not include pregnancy is because California has our own Pregnancy Disability Act. So that's why it's not included within CFRA. We'll talk about FMLA for the 50 plus employers in a minute, but that's why that's why it excludes pregnancy disability, because pregnancy is a total separate benefit. All right, so let's dissect this one a little bit once more and one more time. So, but in a different way. So what's provided? You got 12 weeks unpaid leave. So the good news is it's not paid leave unless there is paid programs that you offer your employees like PTO or sick time or vacation. It also includes insurance premium continuation. So what that means is that, let's say if you offer your employees, you offer me health insurance coverage, and you pay, I'm making this up, you pay 50% of my premium cost, and I pay the other 50% of the premium cost. And then for my dependents, I have to pay 100% of my dependent cost. In that case, for the 12-week period, assuming that I take that full 12 weeks, you are required to continue the 50% of your portion of the health insurance premium during that 12-week period. And I, as well, am required to continue my 50% payment of that insurance premium period. Okay, and then last, it also includes guaranteed reinstatement back to the job the employee had at the time that they left or a comparable job. So again, who's qualified? What qualifies under this? Well, first of all, it's again for the employee's own health condition. And in that particular case, you would require a healthcare provider certification that indicates the period of time in which your employee needs to be out on that CFRA leave to care for their own serious health condition. And when the employee is able to return to work, it also includes a recertification from the healthcare provider saying, hey, Michelle is eligible to return back to work effective whatever date. So those are very two important pieces of documentation that you need to make sure you obtain from your employee when they're ready to go out and when they're eligible to return to work. Now for bonding, this includes both parents. If you have a business in which you have employed both the mother and the father, both parents in your business, they are both eligible for CFRA separately. 50+ employers, take note, this has changed, and I'm going to go through that in more detail in an upcoming slide, but just note that's changed because before you used to be able to tell both parents, they could decide between the two of them how they're going to slice and dice that 12 weeks of CFR leave. That's gone. Now both parents are eligible to take 12 weeks each. There is no certification required on this. All the employee needs to do is come to you and say, hey, I have a new foster child, I have a newborn child, I have an adopted child, and I wish to take bonding time to spend with them. And then the last, of course, is the military exigency. So how is it taken? It can be taken continuous, which is the easiest way to track and record and monitor it, or the employee can take it intermittent. Now, there are situations where members, clients will call in and say, well, gosh, what does intermittent mean? It could mean a whole host of things. It could mean that maybe an employee requests to take the afternoons off 2 days a week. It could mean they want to take full days, 2 days a week. It could mean that they need to take intermittent leave of 3 hours a day, 5 days a week or 3 days a week. It just varies based on what that particular employee's situation is and the requests that they're making of the leave, which makes it a little bit interesting and challenging sometimes in being able to track and monitor it. Now, this is where earlier in the earlier poll, I had mentioned how many of you are 5 to 19 employers, how many of you are 20 to 49 employers. And there is no one on this call today, I don't think, based on the poll that are in the 20 to 49 bucket. So I'm going to talk mostly about the 5 to 19 category. For this group of employers that I believe was, I may have my numbers wrong, I didn't write them down, maybe about 30–40% of you. For this group of employers, what is included in this new law is that they are providing what's called a new mediation pilot program, which ends January 20th, 24. How they came up with that date, I don't know. But anyway, that's the date. What this involves is it allows an employer to request mediation to resolve an alleged CFRA violation within 30 days of a right to sue notice. And the reason why they did this was they recognized that the small employers, they've never had experience in working with employees, requesting, approving, administering CFRA types of leaves. And so they wanted to give them some avenue of relief or assistance if there should be issues that surface in administering these leaves for these employers. The 20 to 49 employers, not so much, because this bucket of employers are familiar with a similar type of leave, and that was through the California New Parent Leave. And if perchance anyone has logged on that is a 20 to 49 employer, take note that if you do have within your employee handbook the new parent leave, you want to replace it with a new policy with CFRA language. All right, let's keep going. Okay, 50+ employers, here we go. This is what's different. This is what's changed within CFRA. And all of these 5 items is what I'm going to focus on in the next slide here. So let's go to it. First one, the size requirement has changed. There used to be this 75-mile radius requirement. That's gone. So now the eligibility within CFRA says it's all employers with 5 employees. There's no more this 75-mile radius requirement. The other item that's changed is the covered family members. As I alluded to and mentioned to in the earlier slide, is that now it includes the grandparents, the grandchild, the adult child over 18 years of age, and the sibling. These folks are now covered within CFRA. Also, job protection for qualifying exigency it was previously included in FMLA, but it wasn't included in CFRA. That is now included with the change in law as of January 1st. And the other item, when both parents are employed by the same employer, each parent now is entitled to 12 weeks. Previously, if you as the employer opted to have them share that 12 weeks, you could. That is no longer okie dokie. And the last thing is we have the key employee status. So once upon a time, before January 1st, it was okay for a business to say, hey, my CEO, my president, my general manager, my executive director, whoever that was, they are vital to our organization. We can't afford them to use this CFRA job protected leave. And so we just can't allow that to happen. That provision is now gone. So what this new CFRA expansion says is that every single employee in your organization, they have a right to reinstatement regardless of their position. Okay, I'm still looking for questions. I'm not seeing anything yet, but Louis, please jump in if you see something that I'm missing. All right, required leaves and employee count. This is another way of slicing and dicing it to say, well, based on my employer size, based on my business size, what do I need to be concerned about? What do I need to make sure that I have within my policies that I'm correctly administering and all of that good stuff? If you're a 0 to 4, again, there's no leave requirements. But again, if because of COVID, you're currently at 4, but you're planning hopefully within the next few months to get back to 5, 6, 7, 8 employees, then absolutely you want to apply this as if you are a 5+ employer, because that's going to change for you very quickly, and you will want to make sure you're administering the CFRA correctly. So the 5 to 49 employers, which was a group that we had here today, there are 2 leave programs you want to pay attention to. The first one is California Pregnancy Disability Leave, and the second one is the California Family Rights Act, CFRA. And I'm going to talk a little bit more about that in the next couple of slides. We didn't have the 20 to 49 bucket. If perchance someone did log in who is in this category, it's exactly the same as the 5 to 49 group. The only difference is that CFRA now replaces the 2018 new parent leave. Now, 50+ employers, no change in terms of the leaves that you need to pay attention to. The only thing I would say is that with the change in CFRA, there's more opportunities now in which stacking leaves could possibly surface. And I'm going to give an example of what that looks like here in the next couple of minutes. Okay, let's get into these 2 examples. First, I'm going to talk to you about when leaves are coordinated. This is for the group of employers where you have 5 to 49 employees. And we're going to talk about Julie, who's come to you and said, hey, I'm pregnant. And you've said, Julie, congratulations. And you're thinking, you know, you're silently, mentally thinking, oh my goodness, now I got to figure out how we're going to manage our business, how we're going to have all the continuity of services, and how I manage this leave. That's what you're thinking. The back end, the front end, you're congratulating her. The second person, we're going to talk about Juan, and this is a stacking example for the 50+ employers. And this is where Juan, I think it's his sister we talk about. She has a serious health condition. And then after he takes care of her, he has his own serious health condition. And how do you manage that? So those are the 2 scenarios we're going to go through. All right, let's talk about Julie. Now, Julie is pregnant. She's come to you, said, hey, I'm pregnant. You've said, congratulations. What is the maximum amount of protected leave? Well, in her case, she is eligible for up to 4 months of pregnancy disability leave. And this must be certified by her healthcare provider. Excuse me, just a second. Now, typically in most cases, it isn't the full 4 months. Typically, it's often going to be somewhere around 6 to 8 weeks. Just know she has up to four months. Plus, now with the change with the CFRA, she has an additional 12 weeks of leave if she's eligible. So remember, your first step, you're going to go back and say, has Julie worked for me 12 months, and it doesn't have to be consecutive. So you and I have to think about this. And has she worked in the past 12 months at least 1,250 hours? If so, if yes to both, she's eligible for the additional 12 weeks to bond with her newborn. So in this scenario, she's eligible for a total of up to almost 7 months of leave, including job protection, and don't forget those insurance premiums. Okay, so here's what I want to do is I want to lay it out a little bit differently because some folks are visual like me. I want to see it. I want to see it charted out. I want to see it visually because just reading the words, they just don't resonate with me. So in her case, it's possible she could be covered with her pregnancy disability and then CFRA, again, up to a maximum of 7 months. What does that look like if we chart it out? Well, first, she's going to have pregnancy disability up to 4 months. Now, again, it has to be as certified by her healthcare provider. Her healthcare provider may only designate her eligible up to 6 or 8 weeks. In this case, we're pretending her healthcare provider has said Julie needs to be out for the full 4-month period. Okay, then what? Now she comes to you and says, hey boss, I want time to bond with my newborn. I'm just having a great time with my son or my daughter, and I now want to take the additional 12 weeks. And so this is how pregnancy disability and CFRA would work simultaneously for the 5 to 49 employer. So, oh goodness, forgive me. I went and I thought I got these animations done correctly. So there I go. Anyway, I'm a lot better at figuring the CFRA stuff out than obviously I am at doing animations and slides. Okay, so here's another scenario. In this particular case, Julie's healthcare provider says Julie was eligible, has been certified for 8 weeks of pregnancy disability leave. So in this case, Julie takes her 8 weeks of pregnancy disability leave, and then she comes to you and says, hey boss, I now want to take advantage of my 12 weeks of CFRA job protected unpaid leave. So in this case, Julie would be out up to 5 months for her pregnancy disability leave. Now, I'm going to ask Lewis to kick us off with a poll because I want to just double check with you to make sure that you heard and understood the type of eligibility Julie would have. So what is the duration of pregnancy disability leave? Is it 4 months or is it up to 4 months as certified by her healthcare provider? And this is not being done as a means to say, well, you're right or you're wrong. It's more just to kind of reinforce understanding of an employee's eligibility. So we're waiting, and as you folks are responding, and if you're thinking, by the way, and you're switching your answers back and forth, because sometimes we do, or I certainly do, that you're just not sure, that's okay too. And unfortunately, I didn't give you that option on this poll. Okay, here we go. So 13% of you said 4 months, and 88% of you said up to 4 months as certified by her healthcare provider. So for those of you who answered 4 months, you're on the right track. Remember, is as certified by her healthcare provider. So the 88% of you who responded, yes, you're absolutely correct. In the case of pregnancy disability, you always want to be guided and directed by that employee's healthcare provider. Because if the employee is not certified by that provider for the full 4 months, you do not need to extend more than what the healthcare provider has indicated. 6, 8 weeks, whatever that might be. So thank you, Louis, for kicking off that poll, and thank you all for responding to that. All right, let's see here. If my slides are frozen. Okay, here we go. All right, let's do another poll here. So here's a scenario in which we're going down to the 50+ employer. I'm switching over, and we're going to talk now about Juan. So Juan comes to you and he says, hey, I need to care for my sister with a serious medical condition. And so he's granted the 12 weeks. And then he comes back to you after that time is over and he says to you, now that I've taken care of my sister, I need to take time for my own medical condition for 12 weeks. And so Louis is going to open up another poll for you here. And based on this scenario, what do you think is the amount of protected leave, the maximum amount of leave that one can take? Is it 12 weeks? Is it 24 weeks? And on this poll, I'm being a little kinder and I'm giving you an option to say you're unsure, because it's always okay to pause and say, wait a minute, I'm just not sure. And especially in those scenarios, we at TPO, again, we do this all the time. We're here to help you, whether you happen to also be a member of TPO, or if you're a client, or you just have never picked up the phone and called us before. Okay, so we're waiting and seeing. I just love these polls, don't you? I think they're fun. Okay, here we go. So 4% of you, or not 4% of you, 50% of you said 12 weeks. So about a little over half of you. 29% of you said 24 weeks, and 14% of you are unsure. Okay, so with the new CFRA, so let me think. Oh, I'm thinking that I got to remember I'm 50+ employers. So in this particular case, one has, in fact, I might as well just show it because I forgot I put the answer in here. So in this particular scenario, one has 12 weeks of CFRA. Again, if he meets all the eligibility criteria that we talked about earlier for his sister's serious medical condition, because remember, CFRA beginning January 1, it added all these additional qualifying family members, including the sibling. So, and also, by the way, 50+ employers, remember the federal FMLA does not cover siblings. So now he also is eligible, once he's done caring for his sister, he now needs care for himself. He's now eligible for an additional 12 weeks of FMLA for his own serious medical condition, again, if he is FMLA eligible. So in this case, yeah, he's eligible for up to a total of 24 weeks of leave plus 24 weeks of those insurance premiums. So this is the significant implications to the 50+ employer. So let's take a look at it on the chart, which I did a little bit better here on my stack, on my animation. So remember, he took the first 12 weeks for his sister, that's CFRA, and then he took the next 12 weeks for himself for FMLA. So this is where you would not be able to run these two leaves concurrently because the eligibility for these leaves is so very different. Okay, so now I'm going to ask you another question, but we're going to reverse it this time. So this time, Juan comes to you and he says, hey, I've got my own serious medical condition. I need to be out for 12 weeks. You grant him that 12 weeks. And then afterwards, he comes back to you and say, hey, boss, now that I'm back and I'm feeling so much better, unfortunately, my sister has a serious medical condition that I need to care for as well. Oh, I see a question that's come in. Let me see if I can grab this. Okay, Steve, excellent, thank you. So if one then has an ill child, followed by a grandchild is ill, is there any limit to how many of these can be stacked? And so I'm going to answer this one live. Oh, so let me type the answer. Let me do this here. So actually, I can't type and talk at the same time. So forgive me. I'm going to answer it live. I'm going to answer it verbally. So in this case, no, the one or whoever it is, if they needed to care first for a child and then a grandchild, and if the employee already used the 12 weeks for his child, then no, it's a maximum of 12 weeks within a 12-month period. So in that scenario, the employee would only be allowed to use the first 12 weeks for, say, his child. If there was a grandchild, then he could come to you and see if there was other leave options, such as if your business offers a personal leave of absence. Don't know if that's a possibility. You would explore that with the employee. But in terms of CFRA or FMLA, each of them separately only provides up to a total of 12 weeks. Now, let me go back to this Q&A before we run the poll. Okay, so please type and let me know if that didn't answer the question for you, and I'll make sure I come back to it. So let's go back, because I think this scenario actually overlaps nicely with the question that came in. So in this scenario, one, he has his own health condition and then requests 12 weeks for his sister. In this case, does he have 12 weeks? Does he have 24 weeks? Or are you unsure about this one? And some of you, as you're responding to it, you might be changing your mind, which I understand, because at times I'll go back and forth. I'll say, wait a minute, is it 12? Is it 24? I'm just not certain. So we're going to see what you folks think, and then I'll share with you the answer. I feel like sometimes we should have the Jeopardy music on, as we're waiting for them to come up with the final Jeopardy answer. Here we go. All right, so 12 weeks, by 38% of you say he gets 12 weeks. 50% of you say 24 weeks, and 13% of you are unsure. Okay, well, let's see what the experts say. And so in this case, one only is eligible up to 12 weeks of FMLA CFRA if he's eligible for his medical condition. Because why? Because to take time off for his own medical condition, that's covered under both CFRA and FMLA. So when he comes to you for his own medical condition, you want to make sure that you run those two concurrently, that they overlap, and and you're crediting those, or you're administering those at the same time. Excuse me, give me a second here. Now, and because of that, to take additional time off for his sister's serious medical condition, that's where you would sit down and explore if there's other options for him. Do you have a personal leave absence policy within your business? If you do, you may be able to extend that as an option for him, but he is no longer eligible for job protected leave under CFRA for his sister's condition. All right, so let's plot it out again. And in this case, so he says, I need to take 12 weeks for my own medical condition. So that's CFRA, and it's also FMLA because it counts for both. And that's where when employees come to you and they request time off for a leave of absence for any of the qualifying reasons, you want to pull out both of those policies. You want to read through them, and that's going to help guide you on how, whether or not do they stack, do they overlap, and how you administer them. So now he also comes to you regarding his sister's medical condition. And in this scenario, as I mentioned earlier, it would be his CFRA is exhausted, and his sister, that eligibility is not included in the FMLA. So the only other possible option might be to explore with him is a personal leave. Okay, so let me go through some of the DFEH resources. And these folks, after today's program, you will be provided a copy of this presentation, and you will be also provided a couple of handouts as well. And so when you receive the copy of this presentation, excuse me, the links that we have here, these are live links and you'll be able to access them directly. And here at TPO, we always advise the folks who call into us, whether it's a member, a client, someone who's never called in before, please, sometimes we'll Google to get the answer. Be so careful. And we instead encourage you to use these links instead, because sometimes you're only getting part of the answer. You might be getting directed to a link that's a federal link, but yet it doesn't give you the information for California. And so that's why we've provided these resource links for you here. Okay, so these are the other handouts that we're going to make available to you. So if you are the 5+ employers, so 5 to 49, this recap gives you a nice overview of everything that I've shared with you this morning. The eligibility, the length of time, what's included. And for those of you who are the 50+ employers, instead, the way we listed it out is we just highlighted what's changed, what's different. I'm just like, TPO, I got it. I know it's CFRA. I just need to know what's different, what's changed. And so we've provided this to you as well. And this will be made available to you after today's program. Okay, what next? So first and foremost, we're here to help you. If you're a member, you can call us. You know to call us at no charge. And I would also, especially with the complexity of CFRA, if you're currently not a member or if you would like to consider being a member, please give me a call. My email link is here. Give anyone a call or kick us an email and just say, hey, I'd like to have a conversation with you about membership. What does it include and how you guys can help us? So please know that's always available. That's not the intent of today's briefing. Our intent is to get the word out, but please know we're here to help. So if you don't give us a call, where do you start? Well, start by understanding the leave interactions, and you can do that by accessing the links that we've included in this presentation. And you want to make sure you understand pregnancy disability leave, the California Family Rights Act, how they are different and what's provided to employees. And for our 50+ employers, you also want to understand predominantly how is FMLA different than CFRA? How is it the same? And make sure that you're comfortable. You've read through all of those legislation, those laws. And in addition, workers' compensation. Now, today I didn't talk about workers' compensation. For one reason, it's because it's just too much information. It's like information overload. It's like if I were sitting through this today, my head would already be kind of swimming. It's like, oh, I just don't know how to get my head around this. And my guidance back to you is you read through it, the information once, and then you do it, then you pause and you step away, and then you come back and you read through it again a second time. Pause, step back, come back it again. Get familiar with the language, get acclimated with the language. Don't panic. You have time. Even if an employee comes to you and says, hey boss, I need to go out I need to request a leave for CFRA. Don't feel like you have to have all of the answers right then. Tell the employee that you thank them for coming forward and talking to you, and then say, look, let's schedule some time tomorrow morning or later this afternoon so that I can come back and provide all of the resources and information that's going to help you in working through this request. And that gives you time to step back, gather your thoughts, and know what questions you need to ask and how you can work and support your employee through this request. Also, the other reason, the one thing I do want you to know as part of today's briefing is that if an employee has a workers' compensation leave, they may be eligible, if they're eligible for CFRA, that those two leaves would overlap with each other and run concurrently. So just put that in the back of your mind. The other thing that you need to do is you need to either create or revise your policies. So if you have not had a CFRA policy in the past because it didn't pertain to you, you need to create a policy. TPO, we're here to help. We can help you build out that policy. If you have an employee handbook, you need to make sure that this policy is embedded in your handbook And if you're the 50 plus employer, you need to make sure your policy reflects all of the current updates within your employee handbook. Also, you want to make sure you update your leave compliance paperwork. This includes that you have all of the appropriate wage replacement insurances that you can provide to your employees, the brochures such as SDI, paid family leave insurance. Remember, these aren't leaves. This is wage replacement to help employees financially as they're transitioning, or excuse me, as they are out on a leave of absence. And it also includes reasonable accommodation, as well as making sure you take account for California's paid sick leave benefit, or whether you offer your own paid sick leave benefit, a PTO benefit, or vacation time. It gets super complicated in weaving through all of these. And so some of you that are on the line, if you're members, you may have a leave management kit, a time away from work kit with TPO. Absolutely, you want to come back to us and make sure that kit gets updated. If you don't have one, pick up the phone, give us a call, and we'd be glad to talk to you about helping you put together a kit and administering these leaves. Everybody has a different role, whether you're the owner of the business, whether you're the CEO, if you're the general manager, if you're the manager supervisor, if you're the payroll administrator, if you're the HR representative. This means different things to each of you. Make sure that you train each of those individuals as they are involved in administering or making sure they follow each of these leaves. Okay, so also what I want to share with you, and it's one of these, it's true, we've got you covered. We're here to help you through this. And again, we're living and breathing it day in and day out. So we're constantly looking at the changes in the laws, the nuances and the definitions. And so we are also offering training to those who would like to participate. You don't have to be a member, you don't have to be a client. So come back and see us on April 7th if you're a 5 to 49 employer for a 2-hour workshop. This is a live virtual event, and this will cover through what we've talked about or what I've shared with you this morning, but it's also good, it will give you more in-depth, deep dive examples of how to administer and manage these leaves. And for the 50 plus folks, if you are in need of additional clarification on stacking leaves, which can get pretty dicey, please, I invite you to join us from 9 to noon on the 8th. And you'll see that TPO HR link there. That's a live link to our website where you can register for training. And I hope to see you there. Also, if you decide to join us for training, this document is one of the documents it highlights, it's the image that I have here for you, highlights what's just a sample of what's contained in our leave management system. And it starts off with this guideline that shows everything that you need to think about or include in managing and administering employee leaves of absence. It includes all of the pamphlets that you need. It includes the forms where an employee would request a leave of absence. It includes forms of a healthcare provider certification form that you need to get for an employee's own health condition. It includes all of the sample letters, or not all of them, but I would say at least 80% of the scenarios in putting together drafting letters to employees in which it approves the leaves, it tells them what their responsibilities are, certainly for their continued health insurance premiums. It gives them information about wage continuation, whether it's SDI or paid family leave insurance, and on and on and on. So what this is saying for you is that if you happen to attend our training, you will then receive a $100 discount for attending either one of the leave interaction workshops towards the purchase of a leave compliance system. And we're making that available to you for attending that training. Okay, I'm going to pause. I'm about 5 minutes before the hour. Please kick through any questions that you have. I don't see any others coming in at the moment, but I'll pause and turn it over to Kimberly.
Thanks so much, Michelle. We really appreciate it. And certainly appreciate the ongoing partnership with TPO Human Resources. The folks over there are great and always answer my calls when I have questions. So thank you. Just want to thank our partners. Certainly, if there are any last minute questions, feel free to put them in the chat. Otherwise, we will be sending out the information for Michelle, and we are recording this webinar. With that, we will send out an email on Monday with that information for you and the link to the webinar itself, so you can cross-reference it. Just want to thank our partners, the Small Business Development Center. Cindy Merzon, thanks for being on the call today, as well as the City of Salinas, the County of Monterey, and again, many thanks to Luis Alvarez of Alvarez Technology Group. And a big thank you to Michelle Stanford, the lead consultant and training specialist at TPO HR. So with that, we appreciate your time today and certainly recognize you have a choice in what you do on a daily basis for work. We really appreciate the opportunity to provide the information for you and hope that you have a great weekend. Take care. Bye-bye.